Hi everyone, my name's Tina Chander and I'm the Head of Employment at Right Hassle. Today I'm joined by my colleague and fantastic solicitor, Gemma.
Hi everyone.
And we are going to talk to you about TUPE and hopefully keep it interesting. So the first thing I think we need to do is actually just figure out what is TUPE. I am sure in the business world you've heard that phrase. So I'm gonna ask Gemma for our benefit. Gemma, what is TUPE?
So first off, it's probably good to start with what does TUPE actually stand for. So it means the Transfer of Undertakings, Protection of Employment Regulations 2006, but overall calls it the TUPE Regulations for ease. And the TUPE transfer occurs in a couple of situations, and it's called when there's a relevant transfer. So the first situation would be if a business transfer takes place, which would be if an organisation or part of that organisation is transferred, so it transfers its main assets across to another employer. The other situation would be a service provision change. So that is when a service is transferred to a new provider. Essentially, they take on a contract for services. For instance, if you outsourced your IT services to another provider, or you took in some services from another provider in-house as well.
And I think it's fair to say in the first example you gave, Gemma, that tends to apply when a business sells to another business, or when part of a business is sold to another business. And in those situations, generally all the employees of that business will transfer across unless it's part of a business, and then only those that are dedicated to the work. In service provision changes, I mean, they're quite interesting because a lot of service provision changes can have gone on for generations because the employees would have started somewhere on a contract and that client might have retendered and those employees then transferred to a completely different organisation, and that process can continue for many years. So whilst they are both TUPE transactions, very often there's a different set of documents to look at and there's different things to be mindful of if you're selling a business or if you're tendering or retendering for services. So in terms of the right steps as to how you address or deal with a TUPE scenario, there's a few steps that you must do, because as with everything in employment law, failure to follow a process can very often lead to tribunal claims. So in terms of the first step, Gemma, how would you summarise what the first step is for an employer to think about?
So the first step depends on which party you are to the TUPE transfer. So what we'll look to focus on is for the transferee's perspective. So that is the business that's either acquiring a business or taking over the service from the transferee, which is the original business. So as Tina mentioned, the first step is to ensure you're taking on the right employees and working out what employees are dedicated to the activities that you're taking on. So that's commonly referred to as an organised grouping of employees. And as Tina mentioned, where you're selling the whole business is transferring, that's quite commonly all of the employees, so it's a bit easier. A relatively simple step there. However, where it's a service provision change, there might be more difficulties understanding which employees are dedicated to the activities in question. Now, there might be some discussion back and forth between you and the transferor to understand which employees are assigned to the work and working out what proportion of their role is linked to the activities to essentially reach a decision of the organised group, which would be those employees that are transferring across.
And when we start looking at employees, whether that's a whole transfer because a business is selling or it's part of a service provision change, for me, as a lawyer, I can absolutely tell you the most crucial thing to consider is, are those employees dedicated to the work that is subject to transfer? So as Gemma mentioned, if you're selling a business, it's fairly straightforward, but it's, the tricky bit or the parts where you really need to think a bit more about how much time an employee spends doing a work that is subject to transfer generally occurs in service provision changes. So let's say we've done that. You've decided it's either all the employees or it's some employees because it's a service provision change. We then have to start looking at actually commencing the formal process. And Another word that's quite commonly used between us lawyers is called ELI, and that's an information document. And Gemma, you've had a go at completing ELI documents for many clients over the years. So please could you just summarise what that is and what it includes?
Of course, yeah. We've commonly done ELI information documents for clients. So essentially, as Tina said, once you've got your organised grouping of employees sorted and agreed, then what you need to do as the transferee is you need to receive the information from the transferor as to the information about the employees you're likely to receive who are in the organised grouping. Now, it's important that you receive that information at least 28 days before any transfer under TUPE regulations take place. Now, what is this information? There's an awful lot of information that you'll want to know about the employees. You're taking them on, so you want to find out as much as you can. So it would include knowing about their written statement of terms, any disciplinary or grievance procedures that might have happened with the employees, any tribunal claims, employee benefits, holiday accrual, anything like that. Essentially, you want to find out as much information about these employees as possible so that you know what terms they're on, because one of the key things in a TUPE transfer is that employees will carry on the same terms of employment afterwards. So you want to ensure you know the information up front so you know what to carry on with. It's vital as well that you're comfortable with the information and you think it's correct. So there might be a bit of back and forth between you and the transferor. You might ask some additional questions or comment on anything that might raise concern, so you are comfortable when the transfer takes place that you know what information is there. And there is the potential to agree indemnities with the transferor if you think there are any concerning areas that gives you a bit of extra added protection in that situation.
And the reason we say this is because very often, as employment lawyers, we deal with situations that occur after a transfer as well. So we very often will receive inquiries from our clients along the lines of an employee cheapied over a few years ago. They said they were on this. We didn't know that. What should we do? And the first thing I will always say to a client in that scenario is, well, have you got the ELI information that was sent to you? And unfortunately, that's generally a no. I don't have it, or I don't know where it is. And, you know, it's so important that you have that ELI information from the seller, because without it, you won't be able to back up what an employee is saying further down the line if there is an issue. So as much as it's quite a time-consuming task filling in the spreadsheet, it's well worth it if you are the seller, so you don't have a situation where a employee is looking to create problems down the line. And if you're the purchaser, it's really important so that you have a record of exactly what that employee is entitled to. Once you've had the ELI information in a form that's acceptable to all parties, you then really need to start thinking about consulting. And in TUPE, we like to call it inform and consult. And the purpose of it is for an employee effectively to not feel blindsided by a process. So, it's good courtesy to actually let an employee know that their role is subject to transfer. But it's also really important because very often the purchaser or the receiving employer, if it's part of a service provision change, may want to make changes or perform the contract in a different manner. And that can bring up all sorts of issues, because the starting point for all TUPE is that the new employer steps into the shoes of the old employer. So if there is going to be changes, whatever they might look like, to terms and conditions, those measures must be discussed as part of informing and consulting. And it's really important that that's done, because failure to inform and consult can lead to tribunal claims as well. In terms of arranging that inform and consult process, it's best to do it holistically with the other side. And that other side might be the purchaser, or it might be the receiving employer as part of a TUPE transfer. But it really, as part of a service provision change, but it's really important just to work with the other side. TUPE does not need to be a contentious process at all. The contentious process arises if parties don't work together and suddenly there are tribunal claims and both employers are listed on a tribunal claim form. I mean, do you think that would be a fair summary of where we ended up dealing with contentious problems, isn't it, Gemma?
You're absolutely right. And I think, as Tina said, just making sure you work together, because you as the transferee have a duty to inform and consult with any employee of the business whose work might be impacted by having these transferring employees come to you. And the transferor has the duty to consult with the employees about any measures, as Tina said, which are sort of changes to their terms of employment. So you need to make sure you give that information to them with enough time for them to be able to undertake that, inform and consult. But it is, the ideal situation is, see if you can go along to the transferor's meetings with their employees, because ultimately they're going to be your employees post-transfer. So it's always good to build good relations from the start, and ensure that everyone's sort of on the same page moving forward.
And after that consultation process is complete, and we have gone through it very quickly with yourselves today, but once we get to that process and we've informed, you've consulted, employees are aware of any changes, and I should add the most popular change is generally pension, because not every employee can offer the exact same pension from a previous employer. But you've got to be able to that process, and then it's actually time to transfer. That should actually be the easy part of the entire TUPE process, because before then, you would have met those employees, liaised with them, informed, consulted, and the process of transfer is literally confirming to the employees on their first day of employment who their new employer is. You might be doing some sort of welcome to the employer gathering. You might need to start some new inductions, because obviously if it's a different premises the employees are transferred over, they should be treated as a new employee in that respect. But your letter will also confirm that their terms and conditions are preserved. It will confirm if there's been any changes. And ultimately, once you've received new employees, whether that's via a corporate or commercial transaction, it's really good practice to try and integrate those employees so you don't have a them and us environment created in the new workplace.
Yeah, definitely. And as Tina said, it's probably good practice as well. If you have looked to making any changes to their terms of employment, then you might want to issue them with a new contract or even a contract variation letter to confirm those changes if you have had any made. A couple of other points just to consider at the point of transfer. The 28 days that we mentioned previously before you get to the transfer, you just want to make sure that time period has passed. And the other point just to consider is what happens if an employee may object to the transfer. So employees have the right to say that they would not like to transfer under the TUPE regulations. They're not forced to do so. What they would do in that situation is let the transferor know that they object to the transfer. They do so in writing. And essentially, from your perspective as the transferee, then what they would do is just update you, because that's a change to the ELI information. They just let you know that employee is not transferring over, and then post-transfer you wouldn't take on responsibility for that employee.
And I would highly recommend that throughout the TUPE process that you do seek HR and or employment law support. Getting it wrong can result in early grievances, tribunal claims, and in all honesty, having dealt with TUPE tribunal matters, it's generally a case of process wasn't followed, which has resulted in a claim, or employees feeling that they should or shouldn't have transferred. So this is why it's so important that when you commence the TUPE process, you follow the correct process from the very word go.
Hope you've enjoyed our discussion today on TUPE, and thank you for listening to episode 4 of the World of Employment Law. Should you have any questions in respect of our podcast, please do not hesitate to get in touch with the team. Thank you.